Welcome to Talking Business, your straight talking guide to dealing with corporate matters. Whether you are a private or public company, an owner managed business or an entrepreneur, a director, company secretary, or in house counsel, this is the podcast for you. My name is Sophie Brooks, and I'm a partner in our corporate team. I was a transactional lawyer for a number of years before becoming a professional support lawyer, which means I'm now responsible for know-how across our corporate team. Hi everyone, welcome to the latest episode of Talking Business. I hope you're all well. I've got a mixed bag of cases for you this week involving both passive investors and sleeping directors. But first up, I've got a case about contracting in a digital age because the High Court has held that an exchange of messages on WhatsApp led to the formation of a legally binding contract. So, under English law, let's remember a contract is formed when there's offer, acceptance, consideration, so some exchange of value, and an intention to create legal relations. And then, as well as all of that, the terms of the contract have to be sufficiently certain. So, obviously, contracts are often formal written documents, but they can also arise by much more informal means, including things like orally or even just through a course of conduct. So, this recent case, which is called Javi Homes Limited versus Fincham, concerned a dispute between a property developer and a demolition contractor who was approached by the developer to carry out demolition works at a site in Norwich. So the contractor initially provided a written quote of £256,000. There were then some discussions between the parties, including via email and WhatsApp, and that led to a reduced price of £248,000. Now, a key exchange occurred on the 17th of May 2023 via WhatsApp when the contractor asked if the job was his. And the developer replied saying yes, and then also mentioned monthly applications. So the contractor responded again on WhatsApp saying, "Are you saying every 28 or 30 days from invoice? That's a yes, not on drawdowns, then good." And the developer replied to that saying, "Okay," and chat in the AM. Now, the contractor maintained that the contract was formed by this exchange of messages on WhatsApp on the 17th of May. And on that basis, the contractor's invoices would be valid as long as they were submitted to the developer and they detailed the work done by the contractor. But the developer argued that the contract wasn't actually formed until the demolition works began on the 30th of May 2023, and crucially, that the contract was based on formal terms that had been emailed by the developer to the contractor on the 26th of May. Now, those formal terms required the contractor to submit applications for payment on a monthly basis with detailed documentation to substantiate the amounts claimed. But actually, the contractor had never acknowledged or replied to that email from the developer, either agreeing to or rejecting the contract terms. So, after the demolition work had begun, the contractor issued several invoices, which the developer contested on the basis that they didn't comply with those formal subcontract terms that had been emailed. So, when it came before the court, the judge agreed with the contractor, finding that those WhatsApp messages exchanged on the 17th of May constituted a binding contract. So the judge said that all the essential elements of contract formation were present at that stage. There'd been an agreed price, a scope of work, and payment terms, and there was no indication at that stage that final terms depended on the agreement of the parties. The judge rejected the developer's argument that the contract required formal written terms and found that the WhatsApp messages sufficiently indicated that intention to create legal relations and agreement on the contract's essential terms. So, having found that the contract was formed by those WhatsApp messages, the subcontract that was sent by email was not relevant at all. Payment terms had been agreed via WhatsApp, so the contractor was entitled to make monthly applications for payment, and they would be paid 28 to 30 days after they'd submitted an invoice. And the formal subcontract terms sent by the developer by email, remember, on the 26th of May, didn't form part of the contract because, in fact, the contract had already been concluded on the 17th of May before those terms were sent. So, a useful confirmation there that informal electronic communications can constitute binding agreements if all of those essential elements of contract formation are present. So, you need to be very careful about the language that you use during negotiations via email, text messages, WhatsApp, whatever means of communication you're using. Simply saying yes to a proposal, particularly if the price and scope have already been discussed, can be interpreted as acceptance of a formal contract. So watch out for that, and obviously establish good, clear protocols for contract formation so you don't get caught out. Ideally, confirming that no contract will arise until a formal document has been signed, and then obviously ensuring that that formal document accurately captures all the relevant terms that you've agreed to. So my next case involves what you might call a sleeping director, if you like, because the High Court has confirmed that an appointment as a director carries responsibilities that cannot be delegated. And directors are under a general duty to inform themselves about the company's business and affairs, and complete inactivity by a director is, by definition, unreasonable. So the case, in this case, it's called Stax Living versus Shergill, and it involved applications by joint liquidators of two companies. Both those companies were wholly owned, controlled, managed by Mr. Shergill. And he had also been the sole director of the two companies, apart from a period of 3 months in 2018 when his partner, Miss Smith, was the sole appointed director of one of the companies called Staffs Furnishing Limited. So Miss Smith was employed elsewhere in the period while she was a director, and she admitted that she'd had no involvement at all in the affairs and business of Staffs during her directorship. And throughout that period, actually, Mr. Shergill had continued to manage and operate the company's business. So Mr. Shergill was effectively a de facto director, a director in fact. But it was Miss Smith that was the only appointed director. So both companies traded as furniture retailers, but they entered compulsory liquidation following petitions being brought by Stafford Borough Council because the companies had failed to pay business rates on their trading premises. So the liquidators' applications included claims for fraudulent trading, wrongful trading, and misfeasance, all under the Insolvency Act. So when it came before the court, one question that the court had to think about was the extent of Miss Smith's liability, given her complete lack of understanding and involvement in the company's affairs. So the court said that both Mr. Shergill and Miss Smith were liable for wrongful trading. So Mr. Shergill actually knew that the company was doomed to fail from the outset. But the case against Smith was based on the fact that she ought to have concluded that there was no reasonable prospect of the company avoiding insolvent liquidation. Now, the judge accepted that Miss Smith did not actually know this and knew nothing about the company's affairs because she took no part in the business. But he said that a director is under a duty to inform themselves about the company's business and affairs, at least to some extent. Miss Smith, remember, was the company's only appointed director during the 3-month period, and she ought to have taken at least rudimentary steps to discover something about the company's business. If she had done that, then she would or ought to have discovered the company's significant liability for business rates, its inability to pay, and its continuation of a failed business. So she ought to have concluded that insolvent liquidation, was unavoidable. But Miss Smith was also then found liable for misfeasance in respect of various unexplained payments that had been made by the company during her directorship. Now, these included payments to Mr. Shergill, cash withdrawals, and payments to retailers. Again, the judge found that Miss Smith had abdicated her duties entirely, breaching her duty by failing to inform herself, to safeguard company property, to ensure records were maintained, and to prevent the improper use of assets. Now, there is a provision in the Companies Act which says that where a director has acted honestly and reasonably, then the court has a discretion and it can relieve the director from liability if that's appropriate in the circumstances. Now, Miss Smith attempted to rely on this provision, saying that she ought to be excused due to the circumstances of her appointment and her non-involvement. But the judge refused this. It didn't carry any weight with the judge, this argument. The judge said, look, complete inactivity by a director is by definition unreasonable and therefore excludes any possibility of the director relying on that particular defence. So a director can't discharge their duty by simply leaving management to others without question. If they delegate uh, some of their activities, which they can do in accordance with the company's constitution if it's permitted, but delegation comes with a parallel obligation to supervise. And that was where Miss Smith had completely failed to do any of that. So, as Miss Smith discovered in this case, directors have to take steps to inform themselves about the company's business, particularly its financial health and its ability to meet its obligations. And if you don't do that, especially when the company is or is becoming insolvent, then that can lead to personal liability for any resulting losses caused to creditors. So I think, if you're an individual and you're asked to become a director of a company, then I think sometimes it's considered almost a badge of honor, isn't it? Or almost in some cases, a time served thing or something. You get that appointment as a director, but you need to be very aware of the fact that um, you that position comes with duties and obligations. You have to understand the company's situation. You have to actively engage with your duties or else decline the appointment, because inaction or ignorance due to lack of involvement will not be a shield against your personal liability as a director. Okay, so my final case, that was our sleeping director. Now let's move on to passive investors, because this case involved Standard Chartered. And it gives a little bit of hope to those kind of passive investors who just rely on a company's disclosed share price rather than specific disclosures of information when they're making their investment decisions. And it's interesting because it contrasts with a previous decision that I had talked about on the podcast, which involved Barclays, the previous case. But in this case, the judge expressed some doubts about the rather restrictive approach that in relation to the question of reliance, which was taken by the court in that earlier case involving Barclays. So this current case, it's only a preliminary ruling, so we'll have to see what happens, but it does keep open the route for those passive investors who rely on share price to possibly have their day in court. So what am I talking about? Well, let me explain. So there are provisions in the Financial Services and Markets Act which establish that there is a statutory liability regime under which companies can be liable in respect of misleading information published to the market. So, for example, in their periodic financial reports, that kind of thing. So, if you're trying to establish a claim under these provisions as an investor, then you have to show that the company's published information contained a misstatement that a director knew was misleading, or there was an omission that a director knew would result in the dishonest concealment of the material fact, or you have to be able to show that there was a dishonest delay by a director in providing information. So we're concerned here with that first leg, so misstatement or omissions. And in order to bring one of those claims for misstatement or omission, the investor has to prove that they relied on the company's published information when deciding what to do with their shares. So when deciding whether to buy shares, sell shares, whatever, to deal in them. Now, some passive investors who've not read a company's published information themselves have instead based their claims on what's known as price or market reliance. It's sometimes known as common reliance or fraud on the market. So that's where a company's share price, so as set by the wider market, is assumed to reflect the contents of all the published information. In making investment decisions based on price, the investors claim that they are still placing reliance on the accuracy of the published information. And it was this category of price market reliance claims that was struck out by the court in the Barclays case on the basis that it didn't meet that statutory requirement for reliance on published information. So in Barclays, the court said, well, you haven't relied on published information. All you've done is relied on just the share price, and that's not enough. So in this new case, it involved a shareholder class action against Standard Chartered that was brought under those relevant provisions about misstatement and omission. There were 217 claimants representing over 1,300 funds, and they alleged that they'd suffered a loss as a result of Standard Chartered having made false or misleading statements in or omissions from published information. So that first leg of claims that I was talking about. And then they also alleged that actually publication of information had been dishonestly delayed under the second leg as well. But following the Barclays decision, Standard Chartered brought an action to strike out the price and market reliance claims of the passive investors on the basis that, as flagged in the Barclays case, this type of reliance didn't meet the statutory requirements. Now, when it came before the court declined to follow the approach taken in that earlier Barclays case, and they refused to strike out both the price market reliance claims and also the dishonest delay claims. But in relation to those price market reliance claims, the judge noted that the question of reliance in the context of these claims is very much a developing area of law, and that complex legal questions of that kind of thing should be resolved at trial in the light of actual and not hypothetical facts. So the judge said he wasn't convinced that the decision in Barclays was wrong, slightly hedging his bets here, but he thought that it was at least arguable that the test for reliance is broader than was concluded in that case, particularly to allow the test to accommodate omissions from published information. And then, in relation to the dishonest delay claims, the judge again said, look, it's a novel point of law. It's going to be better decided on the basis of actual facts at trial. And then he also expressed some doubts about the conclusion reached in the Barclays case on that point, i.e., whether there couldn't be a delay in publishing information unless that information was actually published at a later point in time. So, like I say, the judge very much acknowledged in this case that the issue of reliance in these types of claims is a relatively novel, developing area of law. Um, I think that concept of price market reliance is always going to be difficult to prove at trial. But the fact that it had not been conclusively ruled out at this preliminary stage, I think, is a good sign for those kind of passive investors, which particularly covers a huge number of retail investors, I think, who just rely on that published price information, the market price. If they're not able to show the necessary level of reliance because of the very nature of their trading practices, just relying on the published share price, then passive investors are going to be left without any redress when a company misleads the market. So I think that's why the judge is particularly concerned and wasn't prepared to strike out the claims on the basis of a summary application and said, no, we need this to go to a full trial to think about it in more depth on the basis of the actual facts. So we're going to have to wait now and see whether the case does actually reach a trial and whether those complex questions about reliance raised in both this case and the Barclays one will be answered in due course. So something to watch out for there. Maybe I will be talking about that in a later podcast. Hope you found that interesting, and I will see you next time. Thank you for listening to Talking Business. To find out more about the series, please visit gatelyplc.com/talkingbusiness. From there, you can subscribe for all updates, meet our speakers, and get more information on all of the topics being discussed.